Okay. Welcome, everybody. This is House General and Housing. If that's what you're looking for, you're in the right place. And it is Friday, March 14th, still 2025. And we are now taking up H 461, an act relating to expanding employee access to unpaid leave. We have taken evidence and we have heard witnesses and we have had discussion. And I would ask the committee, we're about to take a vote, Madam Clerk. We're about to take a vote.
Okay.
Is there, oh my goodness. Yeah, all right, she's ready. One last chance, is there anything anyone wants to say before we have a roll call? All right. We are talking about draft number, this is H 461, draft 1.1, dated 3/11/2025, 11:11 a.m. And that is the draft we're working on. Madam Clerk, would you
I
please
move that we,
have it? Yeah, that's right. We have to have a motion. I keep forgetting. You know, in a lot of bodies, I just want to say, oh, but it is the committee bill. Okay, all right. Motion, please.
I move that we, no, I have the brain from walking. I move that we,
You move the bill.
what was it? I move that we
Vote on it?
vote.
No,
No, approve, thanks, Joe. I move that we approve. I move that we approve draft number 1.1 of H 461.
do I hear us? Do I have a second?
So moved.
Okay, we have a second. Bill is on the floor. Madam Clerk, would you please call the roll?
Representative Mahali?
Oh,
He goes
she
last.
goes last.
Sorry, but he's at the top of the list.
I vote
So,
Yes.
Representative Bartley,
Yes.
Representative Krasnow,
Yes.
Representative Burrows is not here. Representative Charlton,
Yes.
Representative Dodge.
Yes.
Representative Dalton. Yes. Representative Howard votes yes. Representative Lamont,
Yes.
Representative Parsons,
No.
Representative Pezzo.
Yes.
Okay, 2, 8. 1. Oh, Representative Mahali,
Yes. Yes. That should be 9,
1-1.
9-1-1.
9-1-1. Right.
All right. So
And who was the reporter?
Ashley's going to be the reporter.
Thank you.
Did you get my last,
That's.
you did.
It depends.
One,
I think.
yeah, okay, so I'll talk about it.
Friday.
There's one more thing we'd like to try to do.
Crossover Friday.
Yeah, crossover.
Yeah. So, okay. All right, so the bill passed, the reporter can contact Nigel and send. What I was told yesterday with respect to the committee bill is that it is no longer necessary for you to sign a copy of the bill. All that you do is send it to legislative council drafting operations.
Downstairs.
Downstairs, you can take it to them or send it to them.
You can sign it and I can take it over. That's the other alternative. You can sign a hard copy.
Okay. Who signs it? The reporter or the chair?
At the top right, I have a copy
At
of
the
the
top right?
top right.
Kathy's down here, thank you. Is really, I think though, you want to send it to Nigel with the vote in here.
It's
Okay.
right here.
All right. Thank you, Sophie, so much for your assistance. We're going to turn now, is Peter in the vicinity? No. Magali, would
He's
you like to
around.
let Peter know that we are ready to go to 106? Thank you. We are gonna do 106, and I suspect it will take us. Peter will. Let's see, we've had, well. Someone refresh my memory. Did we ever walk through one? Okay.
I'll take this one.
There he is. Okay. We're, Peter, we're walking. Here, by camera. Thank you. Okay.
Okay. You don't need to apologize to me.
Walk.
Today.
Great.
Nice.
All right, would you like us to introduce yourself and walk us through H 106 in its current form as it has come to us, and then we can talk about amendments. But first, I think what we'll do is we'll have you walk us through the bill as it is. Then we'll ask Peter Tucker to testify, and then we'll come back to you, Cameron, and talk about what we can do about his testimony.
Okay, if anything, that works. Magali, will you send the Zoom link for me, please, if you don't mind? I don't know if I.
Has anyone noticed that in a few short weeks, Cameron's entire demeanor has changed? He now acts like he's just like.
He's in charge of all of us. He owns us.
Any moment now, you'd be as good as Magali.
I'm not sure that that's possible.
Sorry.
I'm just along for the ride.
Me too.
Okay. For the record, Cameron Wood, Office of Legislative Counsel. We are going to do a walkthrough of H 106. An act related to selling real property within a FEMA mapped flood hazard area. My understanding is this is language that passed last year. And what this does is we're in Title 27, property, Section 380. What this section does is it requires, as you can see in sub A, as part of a contract for the conveyance of real property, the seller shall provide the buyer with the following information. Sub 1, whether the real property is located in a FEMA mapped special flood hazard area. And sub 2 is whether the property is located in a FEMA mapped moderate flood hazard area. Separately, the seller has to notify whether the real property was subject to flooding or flood damage while the seller possessed the property. And 4, whether the seller maintains flood insurance on the property. And then we get into what are the consequences of not providing this information. So failure of the seller to provide the buyer with the information is grounds to terminate the contract prior to transfer of the property. Separate from that, the buyer can bring an action to recover damages and reasonable attorney's fees from the seller. And then in sub D, we have a section that allows for certain protections if the seller, because of any error, inaccuracy, or omission of any information required to be disclosed, when the seller is relying on information provided by a public body or another person with professional license or special knowledge who provided, moving to page 3, a written report that the seller reasonably believed to be correct. And so what this bill will do, as you saw on page 1 and 2, it removes the requirement to notify a buyer when property is located within a FEMA mapped area. Now, here's where it seems straightforward, and it is, if you want the bill to be prospective, meaning moving forward. The issue is, this is a current requirement of individuals selling property. And so what do you do about the individuals who are currently not complying with this section? And so what these last 2 sections will do is retroactively remove an individual's right to sue a seller and recover damages and reasonable attorney's fees for their failure to comply with the section. So that's what section 2 does. So a claim arising from the failure of a seller of real estate to provide the information shall not be eligible for damages, including punitive damages or reasonable attorney's fees. Here's where your bill is not so simple anymore, because this generally on its face goes against constitutional protections against ex post facto laws. Individuals currently have potentially a right to recover damages and reasonable attorney's fees for a seller's failure to comply with this requirement. And what this bill is proposing to do is to remove that right from them retroactively. And so typically, the Constitution's prohibition on ex post facto laws typically applies to criminal penalties in most instances, right? So you can't make something a crime today, which wasn't a crime yesterday, and then charge someone retroactively for said activity. That's prohibited in our Constitution. And when you're talking about it in the criminal context, the courts are pretty strict on that. This is not a criminal issue. This is a civil issue. So I think that this is defensible if you so choose to do this. However, I need you to also be aware that I can't guarantee that a court will not strike that section and allow a claim to move forward in the event someone in between when it went into effect and if you so choose to repeal it has a claim and then goes to court. The seller is going to say this retroactive provision prohibits you from getting damages from me, and the individual who's making that lawsuit can make an argument that this provision is unconstitutional because either A, the ex post facto clause, or potentially you're altering contracts. If the sale of property has occurred, that is a contract, and there's also a contracts clause in the Constitution prohibiting the legislature from amending the obligation of contracts. And so I'm simply letting you all know that that portion of the bill is problematic. I think that it is defensible, and I think that it could be upheld, but I can't guarantee that to you.
Joe,
Makes total sense. What's the possibility of section 2 reading something to the likes that a claim arising from the failure, how are we going to word it? If the failure was because they don't exist, then you are free from it.
So
If the claim was somebody made a claim against you because you didn't have it and it's readily available, it was proven that it was readily available then and they didn't provide it, now you're still liable.
So here's where I will point you to subsection D, because I want to talk about this a little bit, because this is what I've heard. I've heard in drafting the bill and others that, well, you know, sometimes these maps don't exist, or sometimes they're difficult to interpret. You have subsection D, which allows a seller who is relying on information given to them by a public body,
Okay,
it,
so that covers it then.
it protects them.
Okay.
In
then I
the
think we're good
event
then.
there is an error, an inaccuracy, or an omission.
So-
So as long as the seller is making an active attempt to identify whether this information exists, and they are getting information back from a public body, I'm presuming that's their town, telling them, we don't have a map, or I'm looking at the map and I can't tell if my property's in the zone or not, please tell me, and the town says no, and it turns out you are, if you're relying on that assertion,
Yep.
then you are protected. And
I know
so,
what I was looking.
right, so, you know, I'm not going around and buying property on a frequent basis, so I'm not aware of the actual, you know, operations of how that works. But I can tell you legally, there is something here to say protection for the seller in the event it doesn't exist, or it's inaccurate, or it's hard to read, as long as they're taking the active step of getting that validation and information from a public body and doing so.
However, section 2 would now negate that, saying everyone's clear. Whether that information was readily available and accurate and you didn't provide it.
If you pass this law, you're removing, bill, I shouldn't say law. If you pass this bill and it becomes law, you're removing the requirement of the seller to do anything, to make an attempt to identify the area and whether it's in a flood map,
Right.
and then subsequently to provide that information to the buyer. Because you, under the sub 1 and the 2, you're removing that obligation from the seller in this bill. And what we're doing in the section 2 is you're saying there is a period of time in which this statutory requirement existed.
Okay.
And so if someone did not comply with that section during this period of time, when that statutory requirement existed,
Then they're fine.
you're going to retroactively take away a buyer's right to damages in the event somebody didn't provide them with
It's
that.
not true that it's only partial. In other words, your section 2 is taking away, it's taking away a right of a plaintiff, property owner, subsequent buyer, a buyer. It's taking away their right to damages, punitive damages and attorney's fees. It is not taking away their right to rescission.
I would disagree, because when you look at the subsection B, its failure is the grounds to terminate the contract prior to the transfer. And then you get to subsection E, which says non-compliance will not affect the marketability of the title. So if the transaction goes through, the buyer would still be stuck with the property.
Right, but if it doesn't go, in other words. Right, so in other words, if I bought property last year. Or let's say this year, right now, I buy property, it turns out. That I didn't get information that I should have gotten under the law as it is now, I can rescind.
If it's still under contract,
Yeah,
But if
I can
closed-
rescind, yeah.
then no. Subsection B says it's grounds for the buyer to terminate the contract.
You're right, okay, it's prior to the
Transfer
12th,
or
yeah, right, and the contract doesn't really matter after there's a deed, okay.
Right.
All right, I'm with you, okay. And, in terms of section this out, they're not liable for damages for any required to be disclosed to the buyer. An error, inaccuracy, omission based on information provided by a public body. In your view, does that mean the FEMA maps?
Yes, sir.
Okay, so in other words, if it doesn't mean I don't have the obligation under the law. It just means if someone sues me, I'm protected to the extent that I say, well, the map, I looked and the map wasn't there. Am I protected to say I couldn't find the map on the web? I don't know how to do that.
No, what this requires, it requires the seller to make an active attempt to locate the
Right.
information.
Yeah, that's right.
So, going, and what we're talking about, everybody, is we're here in subsection,
D,
D,
yeah,
right? So the seller is not liable for the damages for an error, an inaccuracy, or omission of any of the information when it's based on information provided by a public body or another person with a professional license or special knowledge who provided a written report that the seller reasonably believed to be correct. So it requires the seller to make an active attempt to determine whether or not you're located in a map. But again, if the map doesn't exist, then therefore the seller is telling the individual a map doesn't exist, so I don't know. Or again, if it's the map is difficult to interpret, and so I tell you that, no, it appears that my house is in the map because it's on that side of the road, and it turns out I'm interpreting the map incorrectly because it's not clear to read, and it's the other side of the road, something to that effect. Again, I'm swimming outside my lane and I'll purchase property. Then as long as you can point to, I'm relying on the information that was provided to me by the town, and you've made some sort of active attempt to identify this information, then you would be protected.
right. So D is a defense against liability in the event you're sued. It isn't relief from the obligation. Okay.
And I would say it's a defense, again, to my point, as long as you've made some sort of attempt and you're relying on information provided by it. You can't do nothing and then sit back and say after the fact.
Yeah.
Well, it's not clear because there is no map. Well, if you didn't make that inquiry or, check before you sold it, you're not going to be able to rely on that defense.
Right. Any further questions? Cameron, does that complete your analysis of Bill?
Yes, sir. There's just,
Oh,
there's
and
the,
It's retroact, section 3 is the retroact. Is that, I'm pretty ignorant on this, excuse me for even having to ask. So we can go back in time and make an act retroactively in effect? Okay, and that's what this does.
and there were a few different ways to potentially draft this. This was the one I came up with. I ran it by a few colleagues and they all felt that this is probably the cleanest way to do it. And then again, that's why.
What's-
I know
what's
you have
special
a
about-
question, but that's why the one VSA 214 section 2 is being referenced. I mean, that is a specific statutory section that you have, which ensures that statutes don't go into effect retroactively.
Excuse me, what does that provide?
Let's go to it.
I mean, it's retroactive, but it's not retroactive.
No, we have
No, what I was saying is there is a statute. Yeah. One VSA section 214. So we have these construction of statutes. There is literally a chapter which talks about how your statutes should be structured and interpreted.
Yes.
And so when we go to 214, effect of amendment or repeal.
Yeah,
And this is where it talks about,
afraid I can't quite read. You might either make it a little bigger, yeah.
Thank you.
so, this is where it's talking about the effect of amendments or repeals of actions and how, the amendment or repeal of an act or a statutory provision, except as provided in C, shall not affect suits, remedies, proceedings to enforce or give effect to any right, privilege, obligation, or liability, etc.
Prior,
So, right.
okay,
So this is where, you have statutory sections that discuss, how to enact statutes
Right.
and whether and to what effect they are given. And so that section that we have, the effective date here, was saying notwithstanding that section,
yeah, I see.
we're applying this retroactively.
Why June 17?
That was when that provision went into effect.
Uh-huh.
So at that point, someone
Yeah,
could have a remedy based on,
Between that window and now.
assuming this were to go into effect.
any further questions? Did you, Gail, have one? Yes.
Can you elaborate on E, the non-compliance with the requirements of this section? shall not affect the marketability of title of real property.
Yeah, my understanding of this, and it may be best for me to defer to Peter, somebody who's more of an expert here. Again, I'm new to this game. I read it in kind of conjunction with the sub B earlier. We're selling title to real property, and what you don't want is a buyer who has a claim against someone because the individual did not comply. And now it's going to somehow bring into question the marketability of that deed. So this is saying that even though you may have a claim against the seller and you can go get your damages, et cetera, it's not going to impact the, marketability, resale of that deed, et cetera. It's not going to create any issues with the property itself by the fact that the seller didn't disclose that information when they should have.
So for example, let's say that Cameron conveys title to me and doesn't tell me that it's in a flood. This is under the existing, under this law. And I could, I don't choose to sue him. And I take title of the property, even though he didn't tell me about the flooding and it flooded or whatever. My deed is still valid.
Right.
My deed isn't invalid. I do have property. I could sell it. Of course, I would have obligations, but I could sell it. That there's no implication that his failure to tell me everything he should have told me.
Suddenly means that nobody owns the
That
property. or
that the
that you don't own
property is
the
not,
property.
the title he gave me is not marketable, questionable title. It's a term of art, that a reasonable person could buy it.
I understand that part. It's the marketability
Yeah.
that I didn't understand.
Yeah. So, any other questions of Cameron before we hear from Peter? Can you stay, Cameron? Because I'm sure that there will be more.
You have me until shortly after 2, at which point, well, maybe around 2, I'm going to Ways and Means to
Okay.
walk through your housing bill.
Ooh, lucky them.
So,
Okay, all right.
It's pushed out a little.
sir, sorry.
Cameron,
Yes, sir.
if we decide that we want to go ahead,
No, I gotta.
I just want to know, have you been able to draft potential amendments that either reflect some of the suggestions made or deal with the next section, with section 103?
I may need to talk further about that.
Okay,
I still have significant concerns with the concept of how the amendment came to me
okay, all right,
and how it would work in, like, how I would put it into statute.
okay,
And I'm happy to talk about that.
all right, okay.
Great, thank you. Peter Tucker for the Vermont Association of Realtors. Appreciate the work that Cameron's done on this. I want to make sure that my microphone's off. And I can share my screen effectively. Is it? Start with this one. Great. Well, so this is, so the challenge that realtors have faced, and understand clearly that this is an obligation of the seller. They're our clients. We do our best to help them fulfill their obligations. As this mapping came out June 17th of last year, right after the veto was overridden, we became aware that we really need to help folks figure out, where the FEMA maps are at. So initially, maps have really fallen into 3 different areas. One is a digitalized map that is actually fairly easy to use. It has parcel lines on it. The city of Montpelier, for instance, has a digitalized map, and I'll try and get to that. The second are non-digital map, FEMA maps, which cover, you know, a good chunk of the state, that look just like this. You know, Zone C is not a hazard area. Let me see if I can just draw this over to this corner. Zone B would be a hazard area. But you can see that, you know, the roads are kind of generally on the map. But as far as what the determination is, this was the most challenging thing, I think. Because there are towns that just don't have maps. And that's pretty, you know, it's cut and dry. I mean, there's just no map to look at. But for folks to interpret this map and say, okay, I know where my property is relative to Gold Road, you know, it was extremely challenging. And, you know, and then, you know, as you get into zones where there are multiple zones, the map itself gets a little bit more complicated.
Peter, before you go on from this slide, is the dark zone the flood zone?
It's a body of water, I believe.
Oh.
Yeah.
So
Lower Spectacle Pond, I believe.
yeah, so it's the zone, the flood zone is demarcated how on these raster maps?
That's the problem. It really isn't, you know, other than this one little zone B up in the corner and zone 8A. So, and this is, I mean, I just grabbed a random map. You know, there are maps that are probably, you know, show a little bit more flood zone capable. What I wanted to do is to get out of this and go FEMA layer map. Yeah, beautiful. Okay. And see if this will pop up. Come on. Oh, I stopped share. I got to stop share and then share again. There we go. This is a big file, so it may take a second to come up. There we go. Okay, great. So this is a map of Vermont, the entire state of Vermont. And I think, yeah, I started down on the Massachusetts border, if you can see. And the areas that are in dotted areas are areas that do not have digital maps. And if I go up the state, you'll see that it's, you know, well over half of the state. The orange or red areas have digital maps, and the hash mark area, like this right here, is an area that has no map. So you'll see those. This is probably Pownell and southern Vermont. It'll reconfigure as I go up the state. And you know, there's a decent amount of maps that are good in the state. Here are more hash marked areas, no map available. And so this is what we ran into. This is the problem, you know, is that depending on what town you're in and where you're at, you may or may not have a digital map. You may or may not have the original, they were called paper maps, actually. It was a paper FEMA map that was scanned in, you know, so it's fixed. It's not usable like a digital map. And as you go across the state, you can see the central part of the state has, you know, primarily digital maps.
That's the red?
That's the red. And then the green, as I get up to the north end, you know, as you'd suspect, the Northeast Kingdom, that sort of area does not have great maps. There's Memphremagog right there. And if I open these guys up a little bit, I'll take a second. Come on. There we go. These are all areas that have no map. Oh, I'm sorry, I'm ahead of myself. These are all areas that have no maps at all. So that's a challenge. We're trying to do something that we can address sale of real estate across the entire state. And these are the different scenarios that we're dealing with. Let me switch to this if I can. And this is Montpelier, Vermont. Okay. So this is a map that is digital. And oops, there we go. So you can see the State House, I think, is right here. This is the floodway and the floodplain, the flood hazard area. So on a map like this, it's not incredibly challenging, right? I mean, you can actually click on your lot parcel and get a determination. What I did want to show you here is the key. If I can get down to it. Maybe I can't get down to it. There we go. Well, at any rate, the key really just showed that the green dotted areas, old FEMA did, scanned in maps, and the hash marked areas, FEMA maps that are in places where FEMA maps are not available. So those are the challenges that we faced. The reason that we asked for the removal of the 2 map questions was because it's really difficult for folks to determine. And think about 2 different categories. One, the map isn't there, or the map is an old map, the paper map you can't figure out where your property is. The second area, or the second challenge, are for folks that are computer savvy, who don't have the ability to make that determination in the first place. So with our seller's property information report, one of the things that we do is it's yes, no, or I don't know to a series of questions about the condition of a property. In this case, and the chair had asked me, is there a way to kind of get folks to look at maps, but also to give them the opportunity to say, I can't figure this out. I can't determine it. I don't know. I mean, whatever phrase that is probably usable. So we have a disclosure, a 1-page disclosure that we've been using. It has the map questions, has question 3 and 4 as well. Our suggestion is that making, unable to determine an option for the map questions, either to put them both together and say, hey, I can't figure out whether it's a medium flood zone or a special hazard area. Or have the 2 questions, but with that third option, yes, I'm in a flood zone, no, I'm not, or I can't determine it. And I think that simply that would accomplish the objective that we're looking, to do here.
You have a question here?
Yes.
Yeah, I'm sorry, I don't mean to interrupt.
Oh, no. Yeah, please.
Okay. So when I am doing a closing,
Mhm.
and usually there's a lender involved, I imagine for the
Yes.
majority of transactions in real estate, there's gonna be some kind of lender involved. What do they look for in terms of flood? I mean, because the house itself is gonna be your security, right, for the
Right.
bank?
Right. And the lender.
What do they rely on?
Sure. And so I did track that last year, as this was coming into fruition, to really try to figure out, what do they rely on? And there is actually an engineering firm in Laconia, New Hampshire, that does flood certifications for lenders, and one of my thoughts on this was, if sellers are being required to do it, why can't they just hire the guy that the bank uses to tell them whether, it's in the flood hazard area or not? The challenge there is they don't deal with individuals. They just deal with institutions like banks. So an engineer could take one of those paper maps and figure it out. But an 80-year-old person that's selling their property, might have, how about a 68-year-old person would have challenges? I'll go with me.
It's also, it's my understanding, in my experience, is the checkoff list is at the beginning of the process.
Exactly.
In other words, the
It's before
seller.
the closing, for
It's before-
sure,
Oh, way
right?
before.
I'm
It's
just trying to get at
actually
the.
Exactly. It should be, attached as a.
Yeah,
Yes.
my point is just that if what we're really trying to get at is solve the problem of a property that is in a flood zone gets sold without, regardless of who doesn't know it, like, we want to know whether it is or it's not.
Right.
And this is just getting rid of liability and
It's getting rid of the
frustrated.
seller's
The seller's
obligation.
obligation,
The
yeah.
seller.
The
as
seller's
opposed to
liability.
Liability. As a practical matter, I mean, I don't know, but this is true, Peter. As a practical matter, if this bill passed as is, or if it passed with the checkbox.
Yes.
a seller's form that's clipped onto their offer. At the offer.
The offer to sell their property, right, the listing.
Property, it's listing, so it's the beginning. But if there was no mention of the flood zone and then it got to the point where the bank was looking into it, there would be no deal, right? If the bank didn't want to lend, they wouldn't lend and the deal would fall apart, right?
Right, and so I want to step back for a second and, to address this. And I think that the best way, when we were testifying last year, we said, look, this is a material fact on a property. If it's known to the realtor, if it's known, the realtors have been sued. The wind case over in on the backside of Mansfield, was a big case where the realtor should have known that the shingles were going to blow off the roof, and they were found liable. So, we're always very aware of material facts and if it's a material fact, we want to disclose that. And if a seller says, I don't want you to disclose that, we actually can't take the listing, that's part of our code of ethics as realtors. But this isn't just about realtors, right? This is about all sellers, if it's a for sale by owner, private sale, thing of that nature. Those are all material facts that should occur. The challenge that we had was the form of the disclosure. Requiring the use of FEMA maps, which are at best haphazard. It's not that we don't want to disclose, that our sellers don't want to disclose, but rather that they are unable to make an accurate determination here. So I think that at the get-go, and what's a material fact? It is something that would cause a buyer to change whether or not they wanted to purchase a property, and especially at what price they think the value of the property is. Because I think those are critically important determinations that the buyer needs to be aware of upfront. And as a matter of fact, in addition to adding a checkbox, and what I wanted to show you, this is the form that our forms committee worked really hard on to get to a point where they wanted it. They make sure that there's a link to the FEMA website, a link to the glossary of terms, because that also is, and the glossary changes from a digital map to a paper map. It goes from hash marked areas to just to the code. AE is one area and B is another, and so on and so forth. So the links that the buyer can then take that and go to the FEMA website and do their own due diligence. When I worked with buyers as a buyer agent, I did that for my buyers. I can't do it for a seller because it's a seller's obligation. But in terms of my job to do good due diligence for a buyer, we do that very often. So this is where we're at right now. And I would suggest to you that and I don't, this is where Cameron, I don't know how the language maybe could, it could be changed even more simply to just acknowledge the fact that a seller can make a statement that he cannot determine what the map says about his property.
In other words, you're saying that if the statute said somehow that the seller had a choice between stating that it was or was not, that they could also state unable to determine if they were
They are unable to determine. Yeah,
then you would revise your chart.
exactly.
Right. Statute wouldn't have to contain the chart.
That's correct. Yeah. And I realized, after I sent things to the chair, I realized that really ultimately all we need, and the way the statute's written is that property in a FEMA special hazard area and yes or no, so that other option of I can't determine whether it was not in the statute. We interpreted it literally. That's why we ended up, with a yes or no question. So we would ask to have that third option available to sellers for the two FEMA map questions. And then a disclaimer that allows the buyers to understand that they can search the FEMA website and do their own due diligence as well and give them the connection to that. That wouldn't be statutory. That would be just something we would do in our form.
I'll tell you what I think I'd like to do. Have you made the body of what you want to?
Yes, definitely.
Would you let Cameron come back up? We have him for another 7 minutes.
Okay.
And I'd
Perfect.
like to have.
Far more important than I am.
No, I think people report. So Cameron, you've alluded that you have something to say about this kind of an option. So do you want to let us know what
Well, I
your
think-
thoughts are?
So, yes. And
By the way, just for members of the committee, I did raise by email to Cameron that section 103, this is all in 102 of Act 181. But section 103 of Act 181 imposes kind of very similar obligations on landlords in their leases. And whether we shouldn't address that, in some way as well, if we were going to address this. But I just sent it to him a couple hours ago.
so, yeah, my concern is, again, going back to the language. If the committee wanted to go down the road of having some sort of protection on the seller in the event the seller says, I don't know. I'm trying to take that concept and figure out how to draft it and put it into language. Because let's say that the 1 and 2 remain. It can't simply be that a seller says, I don't know, and therefore they lose, there is no recourse for the buyer. Because then every seller is simply going to say, I don't know. The exception is just going to swallow the requirement. If I'm not required to look and I can just tell you, hey, I'm not sure, go figure it out yourself. And then I'm relieved of my obligation here. What's the point of the obligation? And so then
Sorry, isn't that what it used to be before Act 181? I feel like you could put, I don't know.
Well, I do know from my own experience selling real estate that I don't know is an option on
Right.
all of the questions.
And I don't know if all of those questions come with a specific statutory obligation as
I
this
don't
one
know either.
does.
I would imagine some of them do.
Right.
And so,
Go ahead.
okay.
But just your
Gail
sentence.
has that.
Yeah, go ahead.
Okay, so, my thought is, then how do, if we're trying to articulate it in that a reasonable, an individual has to make some sort of reasonable attempt to identify the information, and if they're unable to, then they can share that information with the seller, with the buyer. I don't understand why you don't already have that in the subsection D.
Subsection D is just protection against liability. It doesn't tell you what your obligation is.
I think they go hand in hand, right? If you don't make an attempt, then you're not going to be able to use D as a shield for
Correct.
protection of liability. So as long as the seller is making an attempt and they say, I don't know, because the map doesn't exist, or it's not in a manner that is readable, then I think that already exists. I would argue that already exists in statute under subsection D, as long as the seller is making an attempt to go identify that information. And so that's where I'm at with the drafting piece. We can draft it and we can say, you can answer, I don't know, and you have no affirmative obligation to make any steps to identify whether or not it's accurate. And if that's the case,
Well, could
it's
you
just,
say-
again, it's going to
could you
swallow
say
the
whether
rule.
the
Why
real
not
property-
remove the
can you
requirement?
say whether the real property is located in a FEMA map special flood area if such information is reasonably available?
Yes, I think we can. It's still going to then require I would argue, if I'm the buyer and I find out that you have told me it's not, can sue you, and then you would need to demonstrate that you made those reasonable steps. So it's not relieving the seller of the obligation that is currently exists.
You had a question, Gail, and then go ahead.
So that was my point, is how do you show that there was due diligence, that the seller made an attempt and shows it in writing that, well, I don't know because I made these steps.
The seller that would be a factual question for the court if that were taken to court. The seller would come in and they could be able to demonstrate, I have these email communications, phone calls to the town, et cetera. They would demonstrate it via that.
I realize this is clearly very important. I am just wondering process wise and with Cameron's time, if we have time to.
Well, we may not, but I want to ask any questions of Cameron that we're asking.
Right,
In the next
okay.
2 minutes. What we do after that is.
And I can go a little longer. I told House Ways and Means I would be there by between 2 and 2:30.
Okay, so go ahead. Did you have a question?
No, I just, okay,
Oh,
If two of the options were FEMA maps are not available or FEMA map is unclear, they would have to do some due diligence to come up with at least those. And if it means asking your realtor or asking somebody in an A&R, they couldn't just check, I have no idea, just not bother. Because then at least you as a buyer would have you would have some criteria to check their work. If you found that there was a FEMA map, then you got an issue. If you find the FEMA map and you're looking at it, the house is right in between two lines, then yeah.
And I agree with you. And the point that I'm trying to make as it relates to an amendment is I think that the current law allows that. I don't see where the issue is with the law that currently
Okay, so
exists.
the law, maybe not. What about the form?
yeah, but nobody sees the law. All they see is the form.
Issue the form.
And the problem is, if I'm sitting there and saying, I don't know, what am I gonna do? I mean, I know as a lawyer what I would do. I would just write in, don't know on the form. But a lot of people don't know they can't. They just have two boxes. Very often, I don't know, is it true that all the other questions are yes or no?
That is correct, yeah.
Yeah, that's weird in Vermont. I mean, most places it's yes, no, don't know.
And that's a policy question for you all of whether you think sellers should be obligated to provide this information. And last year, you all thought that they should.
But your concern is, if I'm interpreting what you're saying, is you're saying, okay, it would be, if we want to, we would take some art in drafting so that they would maintain an obligation if the map was reasonably there or reasonably available. And it would not be, you couldn't just say enable, don't know. You'd have to provide some language about reasonable efforts to maintain, et cetera, or something. I mean, I'm less persuaded by D because D is just defense. The obligation under the law is stated in otherwise, and you might say, well, there's no real, I mean, a section on what you could be sued for me is not the same as a section that says what your obligation is. I think that the realtors are going to feel like what matters is not your defense. What matters is what your obligation. And so if we don't change the obligation, those boxes aren't going to change.
We could, I guess.
A lawyer somewhere along the line who researches it might tell them, don't worry, you made an effort and all that, but that's down the road.
I'm just thinking on the fly here.
Yeah, well, we're all thinking on the fly.
But I have to be the one to write it. To go in the statute.
We'll let you go. Yeah.
So I'm thinking, if you wanted to say, an individual shall not be required to provide the information on A1 and 2. If again, I just go back to the D. We could say, if they determine that a FEMA map does not exist for the location of their house, or if it exists in a way that is not.
One could not reasonably.
Right.
Ascertain.
Right. And so we could draft it that way. And then I think you would potentially need to amend the D to provide them protections from suit as well in that event. So it would be I would potentially rearrange this and have this be an A1, and then these would be A, B, C, and D, and then you would draft an A2 to fit in between 4 and B. That would say an individual, shall not be required to provide the information in A1 and 2 if they, after a reasonable attempt, identify that a FEMA map for their area either doesn't exist or some sort of, reasonably cannot ascertain the location of their property on the map that does exist.
Peter, that deals with the problem of the map. It doesn't deal with the 80-year-old computer illiterate.
Right.
And we just have to live with that. If it was, the realtor would have to help them out.
And assume that liability.
Yeah, right.
Sorry.
Is, how do people have questions with respect to the retroactivity?
Yeah, when did that come up as a concern?
In other words, to clarify, that section, we're talking about section 2. Actually, let me piggyback on his question.
Can I just clarify my
Go ahead.
broader point of asking that? Was that it's been in the ether that this was something we were gonna do, but today was the first time I heard of, well, that's kind of a squishy one a little bit. When was that? Cause like I probably should have had a broader conversation about this is out there gonna happen.
This is my first walkthrough of the bill, so it is my first time to be in front of you all. This was an issue that was, raised at the point it was drafted. Shared with the sponsor.
Peter, you had something.
Yes, I just wanted to say that I am the one that asked for this language in this revision of the bill.
Yeah.
Quite simply, to looking at somebody who during that period of time was in an area that they could not determine where their, where the property was.
Yeah.
And, should they be liable for what is obviously a failure of the FEMA maps during that section of time? I'm listening to Cameron talk about, the protection in Part D. I become much less concerned about that, quite honestly, at this point, because I think that, ultimately the protection would be, look, they changed the rules about the maps, even if the seller was sued over his answer of the map question, then you at least have a good defense to make, right? That we made the change, right, and that caused that, or, was part of the decision.
Yeah.
It is on the front side, this is, it is something that this buyer should know going into the transaction, but if it's just yes or no, there's just this whole part of the state that is going to be incredibly challenging for folks to determine.
Yep.
With seller's information report, which is a non-binding, it's about a 6-page report that we do. Yes, no, and I don't know, are always answers. Typically, sellers will fill it out to the best of their knowledge, and there may be points where they don't know information, and that's why the don't know has always been there. The default to just automatically go to the don't know is a concern. I get it, but I don't think it's a major concern.
Do members of the committee have thoughts? I'm going to just say right now before us, I think, are several questions. Should there be retroactivity or not? That's one question. I'm talking about section 2. Should we leave it in or take it out? That's one. Peter's saying, well, I'm not so worried about it going out because of section D. Another is, shall we ask Ledge Council to draft the kind of thing he was talking about, which is to add a section that to leave in the sections as they are, but the ones requiring FEMA maps, but to add a section somewhat a few paragraphs below that would say not if they've made a reasonable effort to ascertain, they've looked for the maps and it either the map doesn't exist or it cannot be readily applied to the location of the property, something like that. Is that an issue you want him to pursue? I'm just trying to get the committee to give instructions because he can't draft that right now. He's got to go to another committee. So I have a feeling we're not going to be able to get this out today. Cameron, what is your thought on your schedule?
I'm going to House Ways and Means after this, and depending on how long they choose to take on the housing bill, I'm here till you go home, so.
Yes.
I just want to speak for myself. I don't personally feel ready to vote on this today. I mean, I have the privilege of being in this committee from last year. I remember the testimony and being told that this was going to be difficult for sellers and there were consequences to this. Once again, it did. A lot of reasons that bill was not ready to hit the floor, in my personal opinion. We all know there's no such thing as a simple little bill. I absolutely support what this bill is trying to do. But I do not feel comfortable putting my name on this one way or the other right now. So that's just me, especially. Yeah, no.
I was just gonna say, Rob Bartley speaks for me as well. That's how I feel.
So
Not
well,
always.
my question then for the two of you is, do you want a possible amendment language to be drafted whenever it's amended? I mean, whenever it is, to consider, for the committee to consider later.
I know we absolutely have time next week. I think that would be a great time as we're waiting for some things to come over from the Senate, as we're looking at the bills that are on our wall.
Could be a floor amendment to our housing bill,
There you go.
you know?
It could be a floor amendment to our housing bill. So I'm definitely would love to see some amended language. To be really honest, I don't have a super preference on what that amendment language should say. But I definitely think that we have time to discuss it next week.
Right, but on him, meanwhile, how are you feeling about asking Cameron to attempt to draft an amendment along the lines of the discussion that we've had?
I think that would be great.
When he has the capacity.
Right,
I can work on drafting you something.
Right. yeah, we would take it up Tuesday,
Oh, okay.
I think.
Well,
Good week.
No, actually, we might not, but it would be great if we had it by Tuesday.
Yeah,
Yeah.
thank you. I know, I just, I was a little thrown off because I didn't realize like how, I thought we were more clear on this, and then today it got really confusing, and I'm like, wait, how did we end up here? Because I thought, I thought we were way more clear on this. And so for me now I don't even have an option on which to do the amendment or to do the. Because with as it is, it's covered with the D in there. So the repeal, that time frame was still covered, right? Yeah.
I shouldn't speak for others.
So, well, so I'm confused as to what we want to do, what the conflict is, and then what the path forward is. Like, I thought we were clear, and then it went completely not clear.
I think the problem statement that you will hear is, as you know, Mr. Tucker mentioned, there are some maps that don't exist, areas.
Well, yeah, we know that I understand.
And so you do have, if the committee were to want to move something forward to try to alleviate those circumstances.
Yes.
There is the question of people who are currently selling their homes.
Yes,
And not complying with that section.
okay,
And they may not be able to rely on D because they may not be reaching out and asking anyone.
okay,
They may not know
Right.
that the obligation exists. And so the question just becomes, if you want to make an amendment to try to accommodate for some of those situations, do you then give those people some sort of retroactive protection?
okay.
That's what section 2 is.
Yeah, well, that's what I thought that was, so.
Section 2 is,
Question.
um,
So I may be looking at the wrong bill. But the statement of the purpose of the bill is to repeal the requirement. that a seller bill property notice purchase or where the property is located. FEMA.
Yeah, that's the current draft
The bill as introduced
Okay.
would do that.
as introduced.
And it does that and and removes responsibility for the fact that since this was enacted, that hasn't been reliable anyways.
Right. That's what the current bill does.
Okay, that's the current bill?
Yes, that's not
That's
the
what's
current
before.
law, that's the current bill that's in front of us.
That's what we're looking at.
Yeah, to be clear,
Okay.
my feeling was I thought it was overkill. I didn't want to take away the whole FEMA
Okay.
obligation just because not just because, admittedly, that there are some places where there's no FEMA map or places where you can't tell. But I didn't want to just
Throw the whole.
throw the whole thing out. So I talked to Peter about that.
And we're looking for.
And we're looking for something that would allow them, I think, to modify their and allow someone to check, make real the obligation on the seller or continue the obligation on the seller, but accommodate those situations. And that, I think, correct, I agree with Cameron that you would do that by taking something like the language in D and repeating it earlier. So that
Authority. I like what you
it
did
would
there.
essentially say, yeah, you don't have an obligation if you can't, if the map isn't there, or if,
check.
yeah, if the map isn't there and you can't, or you cannot reasonably determine the location of the house.
Okay.
So a lot
And-
of-
Reasonable effort.
Yeah,
so leaving the requirement, strengthening the protection.
right, and
Yes.
so I'm leaving the requirement, but I'm saying,
Yes.
and I think that what that would mean is, I understand the concern, and I want to speak, please, for myself. I understand the concern that there's always the I don't know option, and wouldn't people just check that? Well, I know from my own work, yeah, they can check it, but if they unreasonably check it, they're still going to be liable. In other words, if I check it and there, I'm in there's the map.
Right.
That's not reasonable, and the court's gonna say, sorry, you're not protected by D.
Yeah.
You didn't make the reasonable effort, you didn't do anything.
Right.
There's the map, there's your property, I'm not blind, a judge is
It
gonna,
was
yeah,
available at the time of sale.
yeah, right, it would be at the time.
Right, it might be added later.
Yeah, I would hope, but who knows what the federal government is gonna do, yes.
I don't know.
So anyway, that was my thought.
I like that.
Peter wants.
Peter,
Yeah, Peter Tucker for the Realtors. And I do think that is, I was thinking about something that says after, seller, after best reasonable efforts, has determined that the property is either in or out of the, flood hazard area, or it can't determine something, like a preamble to the two questions. But yeah, that's exactly it, that really, you just want to give them that option if it truly is there. If it's in the city of Montpelier and you've got a digital map, I think you would be hard pressed to say, hey, I couldn't
I
figure
don't know.
this out.
Mhm.
But
Yes.
there are so many maps that can't, so.
And the realtor could, like,
Sure.
verify that the seller, have you done this?
one question here, yeah, go ahead, please, Mary.
Shouldn't the realtor verify with the seller?
Wow.
If
That's our
you're
job.
working for the seller,
Yes.
have you made an attempt to go down to City Hall and look at the maps or whatever?
Or
I mean, and you have,
So,
yes,
yeah.
that's what you're getting paid for.
Yes. But we shouldn't be liable for it.
No, no.
That's part of the problem.
And you have the form, but not all realtors have that form.
But Peter, could you verify that this is the case? Yes, a realtor could and should advise the buyer to carefully fill out the form.
So,
And the seller
Yep.
to fill out the form and not to misrepresent.
that's correct.
Which means if you check yes, you should be like, yes. You check no, it should be no. You check I don't know, it means you really don't know and can't reasonably find out. However, they cannot do the work that the buyer's supposed to do without their taking on the liability. Then it's on them.
However, Peter Tucker for the Realtors, however, if, we have an obligation to make sure the material facts are disclosed. And if we don't do that, that is unprofessional conduct. So it's not like we're off the hook, but rather that we need the sellers to make those representations. And, I would say, a great majority of our realtors, if they see something that's clearly, no, it doesn't pass the smell test, that they would counsel their client to make that change in the disclosure.
Or maybe under, if they check off, I don't know.
Mhm.
What steps did you
Right.
do to try, or, I don't know how you.
Our forums committee, we've had extended discussions on this, like how do you get it right, based on the language that was out there. We're feeling that we need this other category of I don't know, or I can't determine, just based on the quality of the maps.
Mhm.
Is there any obligation to the buyer's realtor?
Just in terms of doing due diligence, I think that, realtors understand all of the different issues, because this is just one issue, right? I mean, there's wind and, all kinds of stuff going on, and all of those things need, if it would change, the way I've always looked at it, if it would change the buyer's interest in purchasing the property, or change the amount of money that they're willing to offer on that property, then those are material facts that need to be upfront. And, it really does need to be at the start of a transaction so buyers can make an accurate determination on the value of the property.
I think you can go. Do you feel that you could draft? What I'd like to be able to do is when we take this up again, things like, do we strike directivity is something we can just do right there. But I think we'd need language to be able to decide whether we want to A, do nothing, B, go with the bill as it is, or C, go with the language.
What I will do with your blessing, committee's blessing, I will draft a strike all amendment from the committee. I will add some language in there as I kind of articulated where I think it would potentially go, trying to capture circumstances we've identified here. And then we'll come back and we can review that. And I'll just have it up as a Word doc and we can.
Right, and then the committee will be able to make decisions on what it wants to do right there, and then we'd be in a position.
Okay.
All right, thank you.
If I don't see you, we'll all have a wonderful weekend.
Thank you.
It is a crossover today, so congratulations. You're welcome. Yeah.
So it is 2:20. What is the pleasure on the committee? At this point, our option, I believe, is either to adjourn. Magali, I'd said the word, but we're not doing it.
Yeah, luckily things don't distract.
Yeah. It's either to adjourn or to just continue a discussion of H57. And our thinking is our alleged counsel is here with us and we could discuss it further if that's what you would like to do. We can't, I don't think we should attempt to vote on H57. Excuse me. It's not a question of voting. It's a question of agreeing on language to give to appropriations. Does everyone understand that? This is an appropriation. They're just looking for direction from us, and we have contradictory evidence on what that desire for direction is. So should we just put it all off until Tuesday, or should we discuss it now? Yes, ma'am.
So we had the privilege of speaking with the chair of appropriations this morning, where she said that if we wanted to wait until next week, given that we had other bills that we wanted to focus on today to be able to pass over, that we can and should wait for next week. And I think that would be beneficial, at least for me, but also for the committee, just to hopefully parse through some of that contradictory information we're getting. So that would be my suggestion.
So we just stop now.
Yep, and we wait until Tuesday.
Others? Anyone disagree? I know the temptation of a gorgeous day outside.
Obliged to agree.
Yeah. But regretfully, yes. Is there anyone who feels strongly otherwise? Surprise. In that case, on Tuesday, the 18th, we will reconvene. The House floor is at 10 a.m., followed by caucuses. So, and after lunch at 1 p.m., we will convene. And at the moment, I believe at that point, we will be discussing H57 and attempting to get to, I would really like to reach a conclusion on H57. You know, our options are to do nothing or to give some instruction, probably in writing, to the approach. Here's what we heard. We heard testimony. Here's what we think. And then by then, you should check your calendars by Tuesday morning, if not later in the evening. On Monday, we will have more calendar items that begin to fill the following days. Anything else? I thank the committee for a very productive and thoughtful week. Really special group. You should all give yourself a small pat on the back. We are in a very complicated environment, and even moving forward slightly as far as we have, has been really an accomplishment. So, and my experience is when it's so easy when you accomplish something to say, well, oh my God, but what about this and what about that? It's coming. Well, that's then. It's important to accept a little bit of appreciation for yourself for what you've done so far. Any final words?